Good afternoon. Could I invite everyone who are guests this afternoon and attendees to attend to your seats, please, so we can start the first session of the afternoon. We're running a little bit late, classically 32 minutes late, and we will start now, so thank you. The caption for this afternoon's discussion is Unlocking Value for Banks. My name is Martin Kenny. I'm from the British Virgin Islands. I'm a fraud lawyer based there with a team of 20 in a land of 32,000 people, 2,000 catamaran sailing vessels, and 480,000 offshore companies, representing 25% of the world's population of such things. And a lot of fraud and corruption cases. Now, I'm joined on the panel today, my far left, your right, is Chris Campanello from Baltimore, Maryland, who is a principal of a firm called Drumcliff, which is one of fraudnet's strategic partners in the area specializing in funding, which helps to open up access to justice for the victims of global economic crime, because you don't get any justice without paying for it in this world. And so we've got the money at the end, which is always of critical importance. Now, sitting to Chris's right, and my left, is Stephen Peters, who's a partner at BDO in the United Kingdom in the area of forensic accounting, but within the context of contentious cross-border or global insolvency cases to find expression for creditors' rights in a cross-border environment. Then next to Stephen is Ian Casewell, who is a partner in the private investigations firm of the Mintz Group based in London. Ian's firm, however, has a global footprint and is headquartered in New York City. It was started by, I think, former journalist in Jim Mintz back in the mid-90s. I knew Jim when he was in an office with two people on 57th Street doing DD work for investment bankers. It's since grown to hundreds of people, I understand. Then next to Ian is James Pomeroy. James I've had the pleasure of working with for many years, is a forensic accountant with the firm of Grant Thornton BVI. And James also gets stuck into insolvency cases, forensic accounting and insolvency being close cousins in our work. So what does this present you? The idea is that these representatives of strategic partners to fraudnet, which is a group of lawyers, present a different face to our work. What's the difference is that their disciplines and their skills are very different from what lawyers are taught to do, which then implies that we lawyers need help of others in order to do our asset recovery work, and that's precisely the point of this panel. So let's move now to the first slide. To talk about phase one in unlocking value for banks. The model we're about to present has 6 phases to it. This is phase one. Each phase represents activity, and at the end of each discrete phase, we pause. We reflect. We look backwards and we look forwards in the management of risk and the journey of a claim going from nothing to, at the end of the 6th phase, cash in the pocket of the victim or the creditor or the insolvency estate, or as the case may be. That's the overarching aim, is to take claims that have apparently little value or no value and realizing lots of value through the application of human effort, money, and the gathering of the all-important facts. Because the only thing we say, standing between a victim and his or her or its money, are facts in large value cases. Because it's hard to burn up $1 billion stolen on wine, women, and song. So when we want to look at first phase, I'm going to invite forensic accountant James to take us to a team like this, showing up at the door of a bank in Beirut and offering, quote, for free, nothing's for free, but with this group it is at the beginning, to take a look at your non-performing loans and to provide some assistance about the valuation of those loans that may be marked to zero now that you've lost money and loans that aren't performing very well. So James, what do you do when you have the opportunity to look at a stack of claims that are in distress?
Sure. Thanks, Martin. And thanks everyone. So as Martin said, in the initial stage, we're looking at triage. So we want to get access to a bank's books and records to do some initial analysis of the accounts. Martin also mentioned funding. And as part of the team, we have litigation funder in Chris at the end. We would ask, is it too early to bring in an external litigation funder? Maybe, maybe not. Firms like ours can work on different fee arrangement models. We can defer our time. But it may be a good idea to bring a potential external funder in, at least to sit and understand what the output is going to be from this initial phase. So what we would look to do is to go in and assuming that the bank has done little or nothing to analyze its, in this case, non-performing loans, but it could be various other types of claims, we would have a look, perhaps help to stratify those potential claims, look at the value of the portfolio, look for what might have some potential early recovery, opportunity for early recovery, and maybe bin some of the ones that are far gone. So with that early analysis, we sort of present the initial findings to the bank, to the legal team that is alongside, and then we kind of feed into the next phase.
So I'm going to invite Chris to answer a question. In this first phase, Chris, as a funder, if you happen to come along with the team for the initial free review, what is the size of the claims? Why is that important to us, and why is that a marker for separating the viable from the hopeless?
Yeah, thanks, Martin. I was actually going to comment on that point. I think one of the most valuable roles that a funder can play at this first stage is to help set the parameters. So like you say, what's the value? Why is that important? If you're looking through a series of non-performing loans and you say, oh, wait a minute, this one looks great, but it's for $500,000. And your funder says, well, wait a minute, we're not going to look at anything less than $10 million.
Why is that?
Because it's expensive. Because litigating, investigating, all these guys, everybody here, cost a lot of money.
So maybe what you're saying is you need some headroom to fit everybody in.
Well, you need headroom to fit everybody in, but if you also need to know that the ultimate value that you're going to recover is going to cover the investment that we put in and some reasonable rate of return. So for a $50,000 loan, it's not going to be worth it. So we can help set some of those parameters at the beginning. In addition, okay, maybe it'll be around jurisdictions. We don't want to touch anything that's in Moldova, right? And this loan is all in Moldova. Then let's put that to the bid.
So what about, Stephen, the antecedent history of a series of claims? Why is the history of what the bank has done or not done, why is that pertinent to a first triage?
Well, I think that I'd just like to pick up something that Chris said actually before I talk about that. I mean, certainly, it's my experience that funders are only really interested in the much larger claims. It's not worth them getting involved in the smaller claims. Now, James mentioned there are various funding models. You referred to doing the work for free. That's possibly one of them, but not the preferred one. But we do work on perhaps CFAs or success fees, and we can talk about that at the outset as well. And the funder, generally comes in a little bit later, in my experience. In terms of your question, it's important to understand the context of the history behind the loan, because actually as part of this triage, this fact-finding assessment that we're doing at the outset, we need to understand some of the limitations in the loan itself, what's been going on, whether there have been possible settlement negotiations that have failed in the past, whether there are any disputes out there, and really get a feel for what's gone on, and that will help us to shape how we approach in the future.
What about questions of, from your perspective, Ian, about the jurisdictional mix when you're looking at the initial run or triage?
Sure. I mean, when we're brought in to have a sort of first blush at the potential targets, we're looking at a number of things. One, jurisdictional footprint of the debtor. We're looking at the jurisdictions that we would consider friendly and like to operate in without too much legal difficulties. We're also trying to focus on what we would consider the low-hanging fruit. In this initial sort of stage, we're looking at the non-performing loans that we think we can realise value in sort of quickly and with minimal sort of effort and investment. I mean, I've worked on multiple cases in many jurisdictions of this nature, and you sometimes find that as time elapses, the debtor, for example, may become complacent. They think the bank has lost interest. It's at this point that people make mistakes, or they invest in assets and jurisdictions out of their home territory where they maybe haven't put the same level of precaution into concealing their assets. And it's these little aspects that we're looking at to find the low-hanging fruit.
While you were...
Sorry, Martin.
Good.
I mean, that's a good point, actually. Ian mentions about low-hanging fruit, and getting the easy wins is really important at this stage, because, again, going back to the funding, if you can get some easy wins and you can realise cash at an early stage, and you can often come to a deal with the bank, with the lender, with the creditor, to use a proportion of those funds to actually investigate and hopefully realise some of the more complex assets.
Well, it could be said that funders haven't been around that long, maybe 10 or 15 years, and we were all doing this work before then. And the hop, skip, and jump model that Stephen's talking about, where you hop onto a piece of low-hanging fruit, an obvious asset, a super yacht, a home, a villa in Florida, freeze it, liquidate it to cash, and that cash can be used to fuel a big operation for recovery. Now, we flipped to phase 2 already. Ian, I'm going to go back to you, because phase 2 is called target profiling, where we're focusing on the target as a part of this, let's say, an input into phase 3, which gets to strategic planning. And why is the target so important in terms of the initial assessment of risk and model building exercises?
Well, we're wanting to understand what their current one, as we've said, jurisdictional footprint is, links to assets which we would consider easy to identify, real estate, yachts, and so forth. Also, what's their current business activities? I mean, if they've now gone and set up another business, maybe they're actually realising value within that. That's a potential target for us to go and recover assets from or disrupt. We're also looking at points of leverage. Certain individuals may have issues to do with tax evasion issues or other white-collar crime aspects. These can all be used as sort of pressure points within future negotiations. So you never go into a battle blind. You want to know your opponent. That first piece of sort of information gathering is what we would consider the easy bit. We're mining public record across multiple jurisdictions, and we're knowing who we're going to go up against, basically.
Do you do some OSI? What is OSI? Open source information, database
open source
research.
Information. I mean, I think in this day and age, people are somewhat dismissive of open source research and are reluctant to pay for it. We all have Google, everyone has access to Lexis, an army of associates that can do research for them. I think there is the volumes of data that we now come up against in the electronic age. The real challenge is cutting through that chaff and getting to the relevant information. So there's a real skill in navigating open source repositories in multiple languages. And there's also great open source information which isn't online, isn't digitized. In many markets, the land registry needs to be searched manually, or the corporate records with the shareholder breakdown are only going to be retrieved by someone going to the registry. So open source doesn't just mean sat in front of a computer. It's a broad discipline.
Do you think, I'll just throw this out on the floor, is big data in the area of the accumulation of public records, do you foresee in a long term access for teams like us to big data could be a game changer for us?
Absolutely, and we're already seeing it. You know, the techniques that we're now using now, you know, the data that we're pulling, and we're using artificial intelligence to actually cut that massive amount of data, which just is unmanageable. You know, a human couldn't do it. So we're using artificial intelligence, we're using complex software to cut that down to manageable levels, so that actually people can add the skills to that, people can interpret that small amount of data. So the interesting thing is there's lots of talk about artificial intelligence and what it's going to do for employment. But all it does is it takes the mundane and the routine out of the equation and allows the individual to actually have a far more fulfilling role.
I think that's such an important point, that AI is not going to replace professionals in our field. But what it's doing is delivering a block of data that can then be worked on by professionals, right? Not replacing us.
Artificial intelligence. We speak in a world of acronyms now. Some people don't know them. James, we're now switching to phase 3. This is called strategy, model building, planning, budgeting, forecasting, activity of teams of professionals on a big job, right? Maybe up to 20 people. In some big cases I've been on, over 150 people in up to 20 jurisdictions. How do you get your head around the strategy and who should be leading that and who should be having inputs, and where do those inputs come from?
Yeah, so I spoke earlier about this being sort of a team model, and how each one of the subspecialties, the accountants, the investigators, the lawyers, have their time and place, and that placement ebbs and flows. So in the first phase, we talked about the forensic accountant doing some of that initial wheat and chaff differentiation, and then followed by phase 2 with the investigators. Now phase 3, you need to look at the legal strategy. So you're using the outputs from those first 2 phases, and now as a team, but driven by the lawyers, starting to formulate what kind of a strategy, a recovery strategy, are you going to implement? And I know we have bullets on there for insolvency. Are we going to try and appoint an insolvency practitioner? Are we going to look at making a criminal complaint? Are we going to look at flat-out litigation? And some of the considerations that might be given include the nature of the asset. Are we looking at corporate entities? What kind of jurisdictions? So if you're looking at filing a criminal complaint in a civil law country, that may be the mechanism there.
What are the purposes, Stephen, of, let's say, a strategy? What are its uses perhaps to the client, to a funder, to the team in assessing our work as we go along? Does it have all these purposes?
Well, the strategy is fundamental. I think we need to stop thinking about assets as your yacht or your house. Some assets can be really, really complex and really off the wall. I'm dealing with a case at the moment where the assets that we're dealing with is actually litigation. I've got a litigation claim in the US, a $10 billion litigation claim that is an asset. Now, we've got a very aggressive creditor who's trying to enforce against this asset. So we're having to seek, and this is one where insolvency was an appropriate route, where we're having to seek protection through Chapter 15 in the US. So the strategic input here, it's crucial to make sure that these complex assets are dealt with in the right way, but also that the right members of the team are involved at the appropriate time.
So I guess, Chris, from a funder's perspective, why is the strategic plan and the budgeting and the forecasting based on that plan of action involving people and their time, their professional time? How does a funder look at the utility, the usefulness, and the importance of a well put together, robust plan?
Again, I think it's vital. we can't, as a funder, drive the strategy. We can't develop it, but we can look at it, and we can see whether, given all of the information on which it's based, whether it's liable to get you to where we want to be, which is recover value. I've looked at some cases which we've been asked to invest in, or actually co-invest in this particular case, and the strategy had already been put together. And it had been put together, the team was already set up, and it was all based on third-party liability in a single jurisdiction. Yet the assets that were stolen are all over the world. So you had this really well-written, well-argued strategy for how to make these third-party liability claims against a bank. Yet the money that was stolen was everywhere, and nobody's even looked at the asset recovery piece of it and trying to bring proprietary claims in jurisdictions where they'd likely be successful. So, we've looked at that and said, okay, well, we'd like to get involved, but we think you have to spend more attention on this. Or you take the decision and say, you know what, this isn't going anywhere because the strategy is just not formed properly.
So implied in what you just said, Chris, is I think an important message about risk management, whether it's the client, the Lebanese bank funding professional fees for its own account, or you as funder. You're talking about spreading risk through a portfolio of different risks, which are different claims. So chase after the assets in where they are, and sue the bank perhaps if it's a good case. So what does that tell us about our work? It means that we have different defendants, and one case can give birth to many, right?
Sure, you can have different defendants, but there are different ways of going after those defendants. So yeah, I mean, in a sense, you spread risk, and it's about setting priorities. Even when you bring a funder in, the amount of funding is not inexhaustible. I mean, there's a finite amount of money that you come in and you say, okay, this is how much we're willing to invest in this case. And if you put it all towards a third-party liability claim, well, maybe you'll recover in 2 years, 3 years, 4 years. But if you put it all in the other claims, the asset recovery, the strictly focused on asset recovery claims, you may get to money faster. So you've got to prioritize. You could do them all, right? But there just may not be enough money and enough bandwidth to do it. So that's why it's so important at this point to think about those things.
So you would prefer to look at speed, timeline, expedition, economy, and perhaps no binary betting, please. Don't you have one bet? You'd like to have many bets going.
Absolutely. Yeah.
Okay.
But I think from my experience is that it's important to have the funder involved when you're talking about strategy. The worst thing you want is for the funder to come in at a later date when they haven't been involved in strategy and say, we disagree with what you've been doing. At that point, you've got a real problem, because at that point, you're not working as a team. You've got the funder possibly imposing his own people onto the case and wanting to drive it in a different direction. And that's obviously no good to anyone.
And hold on, we have to put a pause on this discussion about funding. As much as we love to have funding, we also have fiduciary duties to the client. And that means that the lawyer in the piece might have to pause and say, Mr. Funder, please just hold your horses over there. I need to have a word with the client about choices. Because the client can always choose, if they have capital, to take risks themselves. Because there's a cost to funding, right? You have to earn profit on your capital. Your investors have to earn profit on the capital. The money's not cheap. It could, in my experience, charge as much as in market terms, if the bank is giving a success fee or no win, no fee contract out, the Irish say no full, no fee, then you need to price it based on the market. And typically, in our work, these fee agreements are ranging between minimum 25% up to a maximum of, say, 50% of the value recovered on success fee contracts. Now, of course, the 50% fees are for small cases, very small cases that are hard to fund, where there's no headroom. The larger fees are for the bigger cases. And sometimes they slide down. Sometimes they start at 30%, and after so much is recovered, they go down and down to maybe 2 or 3% over time in big cases. It doesn't matter what the quantum is. The point is it's expensive for the creditor to choose to lay risk off on this team or in partnership with a funder. And so the creditor needs to sit back and say, do I want to pay for the services at no risk to me, or what do I get charged if I use this lot and give them all the risk and give them a big whopping success fee at the end? And it's a choice that has to be made very deliberately, because in some environments, banks can easily make these commercial choices. But if you're dealing with a public corruption case with the people's money, it may be more difficult politically to stomach giving out a large success fee. So, Chris, how do you deal with these issues of competing economic objectives, and how do you price your product in this whole discussion about price and risk for clients?
Oftentimes, the public corruption cases are in countries where they simply don't have the resources to put into, or aren't able to for political reasons. So the flip side of that, on the one hand, it might be difficult to justify paying a success fee, but on the other hand, it's actually hard for some of these governments to do those cases for other political reasons or for financial reasons. But how do we value it? It's a number of factors. It's going to be all of some of the issues that we laid out here for deciding whether a loan is good or bad. It's the jurisdiction. It's what's been done on the case, what the strategy already looks like, how long we think it's going to take. So there are a number of factors. With regard to banks specifically, it's trickier, obviously, because banks, as Ed said, I think earlier, that banks are where the money is. So it's a different kind of a client than a government, because they do have resources. So for them, for a bank, it's a commercial decision that is based on different factors. And so, but we'll look at all those various factors to determine what the return is. At the end of the day, we don't want to make more money than our client gets. So we really do try to keep our percentages down to a point where everybody can walk away from this and say, okay, this was reasonable, right? Nobody got ripped off. Nobody feels like, we took too much for it. But at the same time, like you said, our investors expect a rate of return, and we have to look for that in any one of these funding agreements.
So we're moving now to phase 4, preemptive strike. Ian, in phase 3, you've worked on investigations, you've interviewed witnesses. What is your role to play when it comes time where we're reaching a climax? We have a book of assets we've valued, we're going to pounce on them. What do you get asked to do oftentimes? You get involved in search order work, a forensic review of computer records. What is happening on the day of a preemptive strike for the investigator?
We see ourselves as somewhat purists in the investigation space. So we're fact gatherers, and we're certainly not in the forensic space like my friends here. Leading up to a preemptive strike where we are going to serve a search order, we would be working closely with the lawyers to ensure that all our ducks are lined up. Yes, we could potentially go on that execution of that order. But leading up to that, we're just making sure that the information and the facts are correct to ensure that order is granted, and we are focused on the correct target, should we say.
And if you've had a wish list of people to interview during the secret phase of the investigation, right? Because up to this point, up to phase 3, we should point out the investigation should be done in secrecy.
If we are looking to strike under a degree of surprise. So if we're conducting interviews leading up to that point, we're doing it in a discreet manner. The types of people we are looking to find are people that have fallen out with the debtors, people that have maybe acted in a facilitation way in the past, which maybe realise that what they've done is not correct. But we're doing it in a very careful and thoughtful manner.
But now that we're moving to freeze assets to manage asset flight risk, maybe you would recommend some overt interviews with people that now that secrecy's blown, maybe you could take some more aggressive interview action?
No, exactly. I think with interviewing, there's a number of considerations, but one of the big one is timing. And worked on many cases where there's merit in what we would consider to be noisy interviewing. We're making noise within the marketplace. The debtor's starting to get nervous that we might be disrupting their current business because of that. Reputational damage is starting to come down heavy on them. So and we've heard it before by all of us, we're all saying this is a team game, but the strategy is important. We don't do interviewing lightly. We don't do it at a junction which might come to backfire, like alerting the individual we're going after. And we're ensuring that we're all agreeing that that's the correct step at the correct time.
Now, in this preemptive strike phase, a lot of it has to do with the members of fraudnet, or we sometimes are called comparative preemptive remedy lawyers, preempting the other side with asset freezing orders, search orders, orders taking someone's passport, orders prohibiting them from leaving the jurisdiction, orders to compel them to disclose their assets worldwide within 7 days or face a contempt proceeding and be put in prison. So this is the day, the climax to all the investigation: freeze the assets and compel disclosure of yet more assets to freeze more assets. And perhaps do this all on a Friday. Why a Friday? Because we also have search orders, and we want a weekend to review what's in the personal information devices and laptop computers of the other side. So, Stephen, I would imagine you've been on a Anton Pillar search order execution exercise, or you've been involved in them tangentially to review some of the material that comes out of them. What is the importance of this part of the stage, and how do you gain access quickly over the course of a weekend to advise the legal team about other assets we never knew about?
Well, this is where I put it back to you, Martin, actually, because for me, this is the area where really the lawyers come into their own. So this is where we're working with the lawyers, and the lawyers are doing the legal aspects of it to make sure that we can get in there and do the work that we need to do in terms of pulling the information, securing the information, and starting the analysis of that information.
So if I was in charge of a search team as lawyer, I might ask you as forensic accountant to help us to identify all the banks that these people have been emailing over the last number of years. So that over the weekend, when you give me a list of the banks, guess what I'm going to do? I'm going to write to the General Counsel of all those banks around the world and impose on them, I'm going to infect them with actual knowledge of a fraud, which then imposes a whole series of public law duties where they could go to prison if they tip off the customer or don't freeze the assets, right? So, James, have you been involved in search order work before?
Yeah, we've done, I've worked on Anton Pillar.
We worked together on one in the Bahamas once, I think, in the TradeX case. Right?
Yeah, I've worked on a number of them, and the one, I mean, the time is obviously critical. You need to go in, collect, preserve, process, and examine data from a number of different sources, or hopefully a number of different sources, including computers and mobile devices and external hard drives and that sort of thing. And that, while you can, in the course of time, do a much more thorough investigation of that data, it's key to understand what you're looking for. So there are techniques to look for the kind of information that you're talking about, evidence of banking relationships. So are you doing scans for different combinations of SWIFT numbers and IBAN numbers and that sort of thing? These days now, we obviously give consideration to things like Bitcoin wallets and tokens and evidence of cryptocurrency transactions and that sort of thing.
We have your settlement at the end. Why would you think of a settlement happening so quickly, just because you freeze a load of assets?
In these cases, and again, it's all very situation driven, but if you've got enough pressure in enough pressure points all at the same time, bringing that down, that may be something that prompts an individual or the debtor to come to the table, and they don't want the skirt lifted any further than it already may be.
This is why once I was so dishonorably mentioned in a newspaper in Canada as an international commercial terrorist who practices extortion of debtors by court order. It was a badge of honor. So phase 5, the follow-through, where we continue investigation, intelligence, hold the freeze order, cross-border recognition of insolvency powers, ongoing discovery mechanisms. Stephen, after the dust is settled on the day of the climax of freezing assets, now we're going into another phase of the process, litigation, and there's expert reports need to be done. So I was to instruct you to provide an independent expert report to the court about the meaning of complex financial records. Firstly, you probably are contained. You're probably not involved in the case before now. Why is that, and how do you approach the importance of the independence to the court and the importance of the opinion you're giving and where your duties lie when you're acting as expert?
I think that's fundamental, Martin. You know, my duty is not to a client when I'm an expert. My duty is to the court. So independence is absolutely fundamental. Any sign of you not being independent is just the court would not accept that. It would not be accepted as a professional. You know, your duty is to the court and to the court alone. So it's fundamental that, as you mentioned quite rightly, I could not be tainted by any involvement in the case up to that point. And I come across that a lot in the work I do in contentious insolvency, where I'm working closely with insolvency practitioners who are partners in my firm. Clearly, I cannot be expert for them, so we have to go outside to independent experts when we need them in cases like that.
So we can't even put you in a clean room inside BDO. You have to go to another firm.
So this is why the two of us consider. This is why the two of us can sit on the same stage. We can have a non-testimonial expert or someone who is doing a lot of the forensic analysis of the iterative process of production that's driven by the strategy. So we're talking here about ongoing discovery mechanisms, things like Norwich Pharmacol orders that come up from the initial that come out of the initial analysis, and this iterative process. And you know, it's a very powerful. There are very powerful mechanisms to generate data, and it's interesting for us as forensic accountants to assimilate all of that, look for the unusual patterns, and follow the flow of funds.
Excellent. We're now moving to the last phase. This is getting the cash. So investigate to build a strategy, have a strategy funded, implement the strategy, find the assets, freeze the assets, hold the freeze in the face of sometimes ferocious counterattack, where we're accused of doing all manner of wicked and wanton things to catch the other side sleeping and finding their concealed assets and freezing them. Now we have the litigation phase 5, we get a judgment at the end, and now we have to enforce the judgments, have public auctions of property, the valuation of property, the sale of property, the reduction to cash, and the distribution to the client, to the funder, and maybe some of the folks who did the work. That's the end of the matter. I don't think, any comments about the process of liquidation or at the end of the piece?
Just that as part of the strategy, I think we had some slides on there talking about insolvency and the appointment of a liquidator at different parts of, at different points in this plan can then be, you know, it can follow that the liquidator is part of that recovery or the monetization.
So let's unpack that a little bit. We talked about insolvency without, I think, explaining some of the basic principles of why we use it, right? So if a bank makes a loan to a company and the loan proceeds are stolen by the directors, the bank may not have standing to sue the directors directly. In English law, they don't usually. So that means in order to get at the directors, you've got to first put the company into insolvency and have a liquidator authorized by a judge to sue the directors, to have them held to account. But it also provides us with cross-border investigative powers, superpowers, to find assets and freeze them, because insolvency and bankruptcy courts typically have more power to locate, find, and recover assets than traditional slow-moving civil litigation.
Yeah, so rather than coming at it from the point of view of a third party or a litigant, the litigator steps into the shoes of the company.
Liquidator, the liquidator.
Sorry.
You said litigator.
Sorry, the liquidator steps into the shoes of the entity, and therefore has all the rights and benefits and some limited obligations, but it has the power to go to banks and make demands for banking records. It has the power to enter the premises and take possession. It has the power to go overseas on a cross-border recognition, seeking cross-border recognition of the appointment, and importing some of the powers of the domestic insolvency regime into those foreign jurisdictions, the ability to compel witnesses to speak, for banks and other entities, intermediaries to produce information. So it's a very powerful mechanism from an investigative and asset recovery perspective.
Any other comments? So any questions from the floor? No questions? Well, I would invite you to have a round of applause for the panel. Thank you.
We reach our final session, and it's actually probably one of the most important, if not the most important session, because it's the crux of the matter. We are going to leave this conference with some recommendations on the way forward and how ICC fraudnet can help the banking system in Lebanon, and not just in Lebanon, but also in the region. We start this panel with Maître Karine Chartouni. She is a lawyer admitted to New York and to Beirut. She's currently the executive director at the central bank, head of compliance. She's probably the youngest executive director ever at the central bank. Certainly the first woman to have proved all these achievements at the central bank. And before, she used to work with the IMF before coming back to Lebanon to join the central bank. So the floor is yours, Karine.
Thank you. It's good that women stick together. Women empowerment. So, good afternoon, everyone. Your Excellency, honorable judges, all my colleagues. First, I'm glad to see that people are still staying. It shows that you really are the topic is really very important, and we all want to really fight fraud in Lebanon and around the world. Thank you, Fraudnet and Nada, for inviting us. Thank you, Edward, for saying the good words about Lebanon, especially with the gloomy picture that Camille did. It's good to have ambassadors like you all go around the world and say that Lebanon is really an amazing country. We need that. Just a small introduction about what we do as a compliance department at the central bank. We were established 4 years ago, and with a mandate to ensure that the central bank is compliant with all the laws and regulations locally and internationally. You know, Lebanon is a highly dollarized country, so it's very important to us, and it's our lifeline to keep our connections with our correspondent banks and with international bodies that set policies and regulations. What most of the people don't know is that our mandate extends even more, not like any other compliance department within a bank. It basically, we basically help guide banks on implementing laws, regulations, best practices, including in the area that we are discussing today, and helping them find measures to combat fraud and financial crime. Having said that, I just want to build on 3 points that were discussed today. 3 of the main points discussed, basically, and keeping in mind the topic we're discussing. So first, it's, I mean, people mentioned the banking secrecy as a hurdle to whereby funds or illicit funds are being challenged to Lebanon to be hidden here. This is not true, basically. On the contrary, as His Excellency mentioned, that we, as a central bank, even we took an active part in negotiating the convention itself in Vienna when they started the negotiations, especially for this purpose. And we managed to push here internally in Lebanon to extend the mandate of the SIC, which is chaired by the governor himself, to basically lift the banking secrecy, not automatically, but through we found a way to lift it through the special investigation commission we have, which is our Lebanese FIU. So 2 examples on that, on how we steer the sector towards the fight against financial crime. Basically, part of our goal in following up on the convention after it was signed is to ensure that we implement it within the sector too. So what we did as an example is, for example, is to issue a regulation on beneficial ownership to make sure that our banks identify beneficial ownership of entities. So they're not we don't have entities hiding criminals and people undertaking corruption, crime, financial crime, and what have you. So this is one thing we've implemented. We've also been very active in participating in workshops on fighting financial crime around the world. We even pushed two of the Lebanese people bankers from Lebanon were taking part in an Oslo workshop where we pushed that banks should play a very vital role in ensuring that funds are not challenged through them to hide financial crimes. And we managed to issue recommendations which you can find on the website in this regard. We also were working on the government to issue a package of laws. His Excellencies, the Governor and Camille, and mentioned them. We have already a couple that were issued, like the whistleblower law, the access to information, but we are still missing a lot. Namely the National Commission to Fight Corruption, and which will basically activate our whistleblower law, and the management of all the confiscation assets. At the moment, we don't have a law that governs that. So all these are hopefully in the pipeline, and as the Governor said, the government is being active, at least outspoken, in terms of fighting all these crimes. Don't quote me, I still want my job. The second example about Lebanon is when, in light of the assessment that was done by the OECD, the Global Forum, indeed, regarding the exchange of information for tax purposes and the collaboration of our country, Lebanon, with other countries to fight tax evasion. We also, as a central bank, were a key player, and we pushed for a package of legislation, namely the lifting of banking secrecy, to be able to implement the standards of the OECD, and which we managed to do that because we don't want the stigma of having Lebanon being a tax haven, hiding all these illicit funds derived from fraudulent activities. The second point, I don't know whether you take it as a recommendation or not, is the importance of the governance structure within banks and other entities, and the building of an ethical culture within these institutions, training, educating the people. And this is why we mandated banks to have a compliance structure that will help ensure that these are in place within the entity, adequately staffed with the necessary resources. We even went as far as imposing on banks to have their staff, some of their staffs take an ethical course and take an exam after that. So this is how much we're regulating the industry to avoid all these channeling, avoid them being used as intermediaries or conduits of for facilitating the channeling of illicit funds. We even have them have policies against conflict of interest, and we've done that at the central bank in order to lead by example. The third point, final point, I won't take long, is which is very important to us, as I said at the beginning, is collaborating with all of you, as regulators, with other regulators around the world, to make sure that we respond to all the requests in order that not to have our banks being in the, under being used as entities that are helping financial criminals. Thank you.
Thank you very much, Karine. That was very insightful. Our next speaker is Dr. Claire Dams, who was the federal prosecutor in the Attorney General office in Switzerland, in charge of handling complex multi-jurisdiction anti-bribery and corruption investigations. In 2016, she joined the Basel Institute on Governance as head of legal and case consultancy of the International Center for Asset Recovery. She advised transitional countries on investigation of transnational bribery, corruption, and money laundering. Dr. Dams was the vice chair of the OECD Working Group on Bribery. She's a doctor in law from the University of Basel, and she's an admitted attorney to the Dutch bar. The floor is yours, Dr. Dams. And thank you for having given us the privilege to be with us today.
Either way, is this better? Okay, okay. In any event, I was just about to say, I think I need to manage some expectations, because with all these different heads and all the honors that you've just flashed to me, I'm not even sure that if I would limit myself to 3 recommendations, it would be halfway adequate. So far, I've had the most interesting day, and I don't say that just to be polite, but because I do think that, first of all, there's a very high level of discussion. Second of all, there have been really, really interesting contributions that inspire me, at least, to take away a number of items. But it also inspires me to some critical observations, if those are allowed in this distinguished room. Which is very important. Not every country has that privilege. Anyway, so just to set a little bit of the context, very different than most of the people in the room. I'm not only a criminal lawyer by training, I'm a criminal lawyer by profession. So many of the things that we talk about in the criminal legal sense of the words have different meaning than, for instance, under commercial law, under insolvency law. But we have a couple of common elements. So when I hear in the opening speech that banks frequently are the victim of fraud, there's a little, this is just by way of example, a little red blinking light coming on in my head and saying, yes, that is true, and the shareholders may very well be positioned to file a claim in any kind of procedure. In Switzerland, we have the advantage that that can be done in a criminal procedure at the same time as the criminal trial. But let's be honest, banks very frequently are the facilitators of corruption, of fraud, of any other type of economic crime, including money laundering. So my picture is a very different one, but again, I come only as a simple prosecutor to you, then it might be from other perspectives. I think overall, many of the problems that we have in today's world, be it from insolvency side coming to asset recovery, or from the criminal legal side to asset recovery, are completely self-inflicted. Really completely self-inflicted. What makes me say that? In more recent years, we have taken advantage of borrowing ideas that exist around the world. Now, I have nothing against that. But where I do become critical is when I see, on the one hand, we have a concept in criminal law that criminal law really is the remedy of ultimate resort, isn't it? Well, it no longer seems to be. So we start to borrow concepts out of completely different legal traditions to our own, implement them then in a different legal system, and are surprised that it doesn't work. And at the same time, we're also then saying, well, okay, we implement those concepts, but let's not be too difficult about observing the principles underlying those concepts. Now, let me give you an example. I have nothing against asking people how they explain their wealth. Where you will see me frown is, well, do we really have to do that through a reversal of the burden of proof? Again, this is from a criminal lawyer standpoint. And if so, is that not a clear violation of the right against self-incrimination and all other kinds of principles? And I think that if we're honest, then at least there is a certain tension there. We also see that, overall there is a huge implementation, or I would call it an enforcement gap. Not so much because we're not all being very active and we don't have the will to work on cases. I don't think that that is the issue. But the overall level of detection remains extremely low. In other words, offenders can actually do what we do, isn't it? The FATF requires us and the banking industry to do a risk assessment. And we approach the answers that we formulate based on a national risk assessment study. Well, let's be frank. Criminals do exactly the same. They have a risk assessment that shows them that the cost of doing business is actually still profitable, even if all their assets get criminally confiscated. So it is worthwhile, at least if we're talking about grand corruption cases, to engage in that behavior, because the period of time works in their favor that is needed for investigation, and the money they can make in the meantime while still having that money also works to their favor. So I think we need to be far more critical there and far more creative in how we use means and resources that exist to detect cases, bring material information into, let's say, the preliminary stage of the case. I'm not aware of many countries around the world where, for instance, the use of our strategic partners is forbidden in a preliminary stage. It's not. And so let's imagine that Ian would help law enforcement, Mince would help law enforcement on substantiating allegations of a case, as long as that is brought into the criminal procedure in the proper way and then open to all parties. I really wonder where the problem is. So make best use of legal concepts and don't sort of mingle legal traditions without exactly knowing what the derivation of the concept is. Use the best available resources that one has, and then, be a little bit more cautious about elements of international cooperation. See, let me stay with the same example. Information that does become available through law enforcement ends most of the time, or the capacity to bring that about, ends at the border of the country. Now, for small countries like Switzerland, Lebanon, Liechtenstein, it's not all our countries, but a lot of them, you're very quickly at the border, aren't you? So we then immediately default into what we're trained to do, mutual legal assistance. And most of the colleagues around the world will even engage in that only at a very late stage in the investigation instead of at the beginning. Why not make much better use of the Karen networks, the Egmont Group, and all other kinds of resources that are available to us to bring that material much earlier, but also think about what, as law enforcement, can we actually do to work together with the private practice? And quickly switching my hat now to a private practitioner, as many of you have seen, fraudnet's efforts to actively engage with law enforcement. And, you know, we're not comfortable breathing the same air, using the same words, and actually establish that cooperation. And why is that? Because law enforcement is scared to death that as soon as they engage with the private sector, their case may tumble in court for lack of impartiality during the investigation, which is not the necessary consequence. Perhaps at this stage, one word in relation to bank secrecy, coming out of a country that thrived for many years on that. There is one elephant in the room also there, and I wish you the very best of luck. You're about to face 60 years of explanation, which is what we had to do. In criminal investigations in Switzerland, so to law enforcement authorities, there is not such a thing as bank secrecy. So let me give you a practical example. If I, in my days as prosecutor, would wish to obtain banking information about a certain set of accounts, the bank, although legally obliged based on the banking law or the provisions of banking law, could not invoke the banking secrecy vis-à-vis law enforcement. In other words, within 5 days, I had the banking information. So what that caused, of course, is a discussion around the world. Switzerland is this really impossible country because you have bank secrecy and because it is impossible to obtain information. Now, the first one is a myth to be killed immediately. The second one is then, if that information needs to be shared at international level, of course it needs to be of potential, not even real, potential relevance for the investigation in another country. So that might be something to draw from. Am I negative? No, but I'm critical, and I think that we're so far away from using concepts in the sense that they were written that causes a tad bit of, let's say, the difficulties that we're facing in tackling this type of crime today. Thank you.
Thank you for the critical approach, which is very helpful. And I personally had the experience with the Swiss federal prosecutions providing us, we were partie civile, providing the prosecutor with very detailed information about financial flaws in the Swiss banks, about the indicted person. Of course, we didn't find out ourselves, we didn't find out this until later when the investigation was already completed. Our next speaker, His Excellency Mr. Demianos Kattar, he was the former Minister of Economy and Finance in Lebanon. And he is a strategic advisor on policy issues. He's very highly regarded as a former public official, which is not always the case in Lebanon. His credibility is, I do not exaggerate by saying that he has an unparalleled credibility in the society and amongst the business sector and the political scene. He was involved in establishing major academic institutions and universities. He is sought after as an independent board member. He sits on banks, financial institutions, and some multinational boards. Khalas. And he's asking me to stop here. So the floor is yours, Mr. Kattar.
I don't know. I'm very impressed by the room, by the way. I have seen other colloque where we were around 6, 7 to close at 4 o'clock. So I thank the audience to be really interested that far. And I want to thank the visitors of Lebanon to accept to bring this forum to Lebanon. Because when we call her Mater Nada, when Mater Nada spoke to me about this initiative, I said, do you think they will come? No, we were not sure if all this negative press about Lebanon around the globe, about the banking sector, about the downgrading, about the sovereign issue, about collapsing faster than Greece and Argentina, would allow lawyers so brilliant like you, seeking money where it is also, and be able to come and stay here and share your knowledge. While listening to you, I'm not unemployed, but I dedicated the whole day today in order to learn, and I learned a lot, and part of my learning helped me for the, if I can say, some thoughts rather than recommendation. There is a high level of intellectual part in this day. Concepts, strategies, global knowledge, and I think the first thought I had, can we embrace in Lebanon your initiative with all law schools? Can we call on law schools in Lebanon to create a channel with your network and enhance the knowledge of the people about this asset, as you said during the day, not only freezing, but also the whole process before and the whole process later. Second thought I had, with the Association of Banks, would create a department or an office in order to link the platform between the judiciary system, the lawmakers, and the victims. Because as you mentioned, the victims not always only banks. And the idea would be, is it feasible for the Association of Lebanese Banks, where the money is, to really create this entity and start developing slowly, the belief that you can find, freeze, and reconsider the redistribution equally when you identify through the judiciary system what to do. The third thought I had was listening to all of you from different experiences also. We're missing still a lot of practical funded or founded texts. We have a lot of initiative at the central bank. We had a lot of initiative at the parliament, but until today, the problem we're having in Lebanon, not the evidence proof, is that we will continue in the process until we reach a result. I have listened, many experiences has been presented, took a long time, took a lot of effort. And I listened to statistical 2% of what have been reported to police really get into a certain seriousness action and how many was really conducted. So the question, third element of thought would be, can we really create a mechanism to create the real action for a result? Minister Buslayman was a friend of mine, highlighted the public debt, the mismanagement. This is true. But what we're doing today is the other part, is the civic initiative that will try to create, with all dedicated people in Lebanon, an initiative that will try to counter the bad management approach. In your countries, when somebody loses election, he leaves. In Lebanon, if somebody loses the election, becomes a victim and gain power. In your country, when somebody finishes mandate, leaves and go home. And Lebanon will stay in his chair because of public interest. So there is perception management that I think your initiative would help in order to drive people in changing the perception about public interest and the word used by Professor Wright this morning, the unexplained wealth. And the unexplained wealth deserve a research in Lebanon in order to identify what does it mean, unexplained wealth. And could we justify in a sectarian way or through the victims of war or through political gurus that unexplained wealth has different meaning than the meaning of Professor Wright this morning? I think it deserves that this momentum of today becomes a pillar into these four momentums. The momentum of law school, embracing serious approach about what you tried to achieve over the last 14 years. The second element will be the platform at the banking sector. As you said, sometimes the bank is a victim, sometimes the bank is a channel. So it's very important for us to make sure that the association of banks where their interest lies, because they believe at the central bank their interest is there, but it's a regulatory behavior. So how can we create a platform that really follows this initiative? How the central bank and the policymakers and the judiciary system could enhance the text that would allow really not to go into, I don't know if we can approach the disruptive environment in Lebanon so easily, because everything in Lebanon is disruptive. So we need maybe an intelligence a little bit beyond the normal human intelligence to get into disruptive behavior of a disruptive model. So I think this deserves a separate discussion. And the last thought for me is the momentum we can create by embracing other civic initiatives around you to support your initiative. Finally, you're a group of brilliant lawyers around the globe believing that we can do something for victims and we can have our rewards from it, and it's all this legitimate. In our country, we need a little bit further. We need to create a perception change. 5 billion, we recap 400. For our population, it's not enough. They want a perception they can really follow the corrupted person till the end. We proposed last year that we need from state civil servant a revenue declaration every year. Not when you enter and when you leave, because he could enter at 20, leave at 60. So he will have 40 years to build income from criminal acts. What we want to know is the yearly revenue of these state civil servants. I'm not talking taxation, mind. I'm talking only to make sure if that this cumulative wealth is on the regular and ethical approach or it's a different path. And here the banks will start feeling a little bit the heat. Because if he announced a high revenue, you will ask him where it was, then he will tell you in this bank account, and then the bank has to react differently. The last point in my short intervention to respect the timeline is that Lebanon has a large shadow economy. And when we talk about Switzerland and we talk that the border is so close, but the shadow economy in Switzerland is 7.8% according to 2018 statistics. In Lebanon, small borders, but large shadow economy. And the economy being in Lebanon 55 billion, our shadow economy is around 32% plus according to last year statistics. So in shadow economy, you know very well that you will not find banks, and you will not find traceability easy. And the intelligence you have mentioned several times in your presentation could be part of this shadow economy. So it's very important, I think, to push more and more our efforts also on the shadow economy and not only on the declared, announced, usual institutional economic agent. I think with this small thoughts, I want to thank you for the whole learning I received today during the day, and I wish you success, and I hope other civic initiatives will be around you and support and empower our judiciary system, which we believe in, our policy makers, we would like to believe in a little bit more. Thank you.
I would like to pick up on the... There is an idea that was all day, coming back and forth throughout the various interventions. Professor Ryder spoke about restitution. The governor mentioned not confiscation, but in other terms it is confiscation when we return the money to the Tunisian government. At the same time, we have some loopholes in the framework, in the legal infrastructure concerning confiscation and restitution. So let's suppose that the money was found, the dirty money, it was frozen, and then what? How does it reach back the victim, or maybe the government, or the stakeholders? That's also another question to determine who should get the money. But here we have some loopholes, and if I may suggest that, so maybe what we can do as fraudnet is to start like a comparative analysis, or a comparative paper, not start, actually undertake a comparative analysis to see how we can improve the confiscation, restitution problems and issues that we have in the Lebanese system. We could do that for Lebanon, we could do that for other countries, but I know that in Lebanon there is a policy interest in that, and I've heard it from the governor of the central bank. So if you agree with me, and that would also capture the various philosophies of the various legal regimes. So you have common law, civil law, because Dr. Dams, you mentioned that sometimes we just cut and paste concepts from another country and we try to implement it in a civil law country, for example, and it's just out of context and it doesn't really work. And also during Professor Ryder's speech, he spoke about the intent that sometimes that what they've introduced in the UK, the strict liability, where you do not have to prove the intent. We have this hurdle in Lebanon, for example. You have a CEO of a company or a PDG, Chairman General Manager, receiving kickoffs from, or commissions from providers, from suppliers. So he's the CEO, instead of buying a chair for $10, so paying $10 to the provider, he would pay 10, and out of the 10, the supplier would give him back $2. Is this a crime? Of course, I think yes, but there is no text that actually puts that as obviously, and it's not just in Lebanon. Many civil countries still do not have express texts about that. So in Lebanon, it depends how the judge is interpreting the text. So if it's a strict judge on values and ethics, the answer will be, of course, it's a crime, because the chairman general manager is the attorney, is a proxy, and he's the fiduciary of the shareholders' money. This is just like one example of legal loopholes that will pop up when someone is doing a comparative analysis. To go back to the banking system, there is an issue with the confiscation. We do need the enactment of confiscation law. So maybe we can suggest this comparative legal study to try to enact laws. Your recommendation, Your Excellency, is in the university, law schools, to create to establish a unit that will combine, to establish a unit combining compliance, law, and financial background, so that the business persons have the proper compliance and legal background, and the lawyers and the judges, when I say lawyers, I mean jurists, have the proper financial background on how to trace the funds. If the floor is open for any further suggestion or questions, if you have. Yes? Can we have a microphone over there, please? I don't know if they... Yes. You have a recommendation.
Excuse me. Well, I'm not quite sure. I mean, in terms of your legal comparison, that would be easily filling another 2-hour session. There's a couple of examples that come to mind. Even, countries represented in this room. But an item that was very lightly touched upon today was corporate liability. And obviously, we have talked about that in the context of banks being liable, and that could be both criminal liability as well as civil liability. But I think that one item, if my understanding is not completely wrong, that you might want to devote some attention to is how do you actually formulate and structure your criminal liability law vis-à-vis companies. Coming out of the Roman, with a bit of German influence, tradition, the question there to be addressed is, well, can a corporation actually commit a crime? Yes or no? And even the Germans, who were the last remaining standing gladiator in that field, have now admitted that they need to adapt their law, and that there is indeed such a thing as, well, what in English terminology would be criminal mind and alike, that can be attributed to a corporate entity. I think for this country, again, that would not be the proper consideration because you come out of a different tradition, but I do think that it is an element that might have an enormous effect in terms of holding people accountable, holding entities accountable, and create the perception within the population that, if you run a company and you're successful in doing so, you're not beyond the reach of law, and therefore you reduce the impunity gap in that area.
Sure, I took note of that, but just to mention that we do have corporate criminal liability in Lebanon, and in the penal code, corporations can be liable, and the penalty is can go to the shutting down of the corporation, en passant par issuing a communiqué about the company, etc. We do have it. It's not well used. It's not tapped on. I mean, in my years of experience, I think I have never seen a company being a judgment deciding that the company is criminally liable and therefore must close. So maybe we need some precedent, absolutely, I'm noted down. We had a question there? I will confiscate this microphone.
First, and fraudnet, I learned tremendously today. A thought come to mind. You see today in the schools, whether starting from a young age and even in companies, people touch a lot on corporate social responsibility. They speak heavily about sustainability, taught very early on in the school, the environment, green energy. I think the subject of fraud, when it is taught from school, discussed in an honest and open way in companies, it gives more awareness to people. Again, it depends on every country. There is a clear corruption index listing the countries today that people are familiar with. But I think the subject of fraud, when it's no longer a taboo in certain geographies, it is acted upon with a proper judicial system, it will start to make a difference. Maybe step by step, like a snowball effect. But even today, you are starting by raising the bar. And I'm very happy to hear also about the BDL compliance that Karine spoke of. Despite all the problems in the country, the BDL is still compliant. It's still respected internationally because of steps it took. So just this is the idea that I'd like to share with the room. Thank you.
Thank you. Any intervention or question from the judges, the fraudnet members? So what we will do is we will be issuing a wrap-up report or communique about the conference, and we will be circulating it. But before we officially close, and by the way, whoever did not give us their email, please feel free to drop your email in the outside in the containers. Before we close, I would like, in the name of ICC Fraudnet and with the help of our executive director, Ed, to offer you a token of recognition, thanking you for your participation. Maître Karine Chartouni, Dr. Dams, and Your Excellency, Mr. Qatar, thank you very much for having given us the privilege of your participation. Thank you.